Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast, the podcast where you can actually listen to bar lessons while you're driving, or while you're in the airplane, or while you're in the subway, etc. So, this next episode is on pretrial procedures. So, one of my favorite classes in law school was, pretrial preparation, all the things you do before you get to trial. And I think when you work as a judicial law clerk, you deal with a lot of these pretrial procedures. Anyhow, to introduce myself, again, I'm Angela. I'm a law student just like you, studying for the bar exam. I feel like I've been studying for the bar exam forever. Yes, this isn't my first bar exam rodeo, but hopefully it will be my last. I've created this podcast for me, basically, to pass the bar. But if you pass it, then that's a bonus as well. So here's what we've done. I'm not an expert in any of this. I mean, I should be, maybe by the amount of studying that I've done, copious amounts of studying. But I've taken lots of notes over the years, and I've put all my notes into AI, and I've had these podcasts generated. So I use an app that generates podcasts, and you have a male voice and a female voice. I've named them Maud and Claude. Who knows what their real names are, but they're bots. And what they do is they digest all my notes. So they've digested all these notes, and out of it has come this podcast. Anyhow, if you need to get in touch with me, if you want to talk to me about any podcast stuff, you can reach me at podcast@studyforthebarinyourcar.com. But if you'd like to get in touch with me for any legal work, so maybe you're an attorney, and I say attorney because attorneys do sometimes still take bar exams. So if you're an attorney, or if you know an attorney who needs some sort of legal help or law clerk work, I'm sort of like a freelance gun for hire for attorneys, and attorneys who are oversubscribed with work or need an extra set of hands. I do motions, appeals, etc. For my legal work, you can reach me at hello@legalwriterandlawclerk.com. Anyhow, a few reminders. I am not an attorney. I am not giving legal advice. AI isn't always perfect, so sometimes you'll notice some things that aren't quite right, but I do my best to make sure that the content that is put out is correct, or as correct as it can be for someone who has graduated from 2 different law schools but not yet passed the bar. And 3, be safe while you're driving. Make sure that if this content is going to have some sort of reaction, maybe you might want to pull over or press pause, because God knows civil procedure can rile up anyone's blood pressure, right? Anyhow, so without further ado, here are our AI host, Maud and Claude, to go over pretrial procedures in civil procedure.
Welcome to this deep dive, especially for everyone tuning into the Study for the Bar in Your Car podcast. We really want to thank Angela. She's an LLM law student who shared her fantastic notes on pretrial procedures. They're really the foundation for our chat today.
Yeah, absolutely. Today we're digging into, a really fundamental part of any lawsuit. Everything that needs to happen before you even get close to a trial. Think of it as, understanding the map and the opening moves in a legal case. These steps shape so much of what comes later.
Exactly. And Angela's notes are like our roadmap here. We'll start with those really urgent actions like temporary restraining orders. Then we'll walk through pleadings, the whole discovery phase, getting information, and wrap up with things like pretrial conferences. The goal is simple. Break down the key stuff so you can really get a handle on these concepts for the bar.
Okay, let's kick off with those immediate actions. Preliminary injunctions and temporary restraining orders, or TROs. These are basically court orders telling someone to do something or maybe stop doing something before the case is fully decided.
All right, so a TRO sounds like it's for when things are really urgent, short-term stuff.
Yeah.
Angela's notes mentioned, 14 days, maybe extended once?
That's the standard, 14 days, potentially another 14 if there's good cause.
Right.
And what's really interesting is you might even get one without notifying the other side initially. That's called ex parte. But you have to show immediate irreparable harm would happen otherwise and certify what steps you took to try and give notice.
Okay, so getting one without notice is a high bar. What's the strategic play in seeking a TRO? Why go for that immediate hit?
Well, strategically, it can, force the other side's hand really early. They have to react fast, maybe even think about settling sooner. It freezes the situation, preserves the status quo. But like Angela notes point out, the requirements are super strict. The order itself has to be crystal clear. It needs to state the reasons, the specific terms, exactly what acts are restrained or required. You can't just say, see the complaint. It has to stand on its own.
That makes total sense. It needs to be unambiguous. Angela's notes had that example, trying to extend a TRO because a witness is going on vacation. That sounds like a no-go for good cause, right?
Oh, almost certainly not. A vacation, that's foreseeable. Good cause is usually something unexpected that stops you from having a hearing on a preliminary injunction quickly. Like, maybe a key person gets suddenly ill or crucial new evidence pops up right before the hearing.
Got it. So unforeseen obstacles. Now, Angela also highlights this difference between a TRO and a preliminary injunction. The duration matters.
Big time. If a TRO lasts longer than 28 days in total, that's the initial 14 plus 1 14-day extension. Or if it's just open-ended, the court treats it like a preliminary injunction. And that's huge because preliminary injunctions are immediately appealable. A TRO generally isn't.
Ah, okay. Appealability is key.
Right, and even if a TRO is issued with notice to the other side, if it's set to last longer than 14 days from the get-go, it's also treated as a preliminary injunction.
So, notice and duration flip the switch. And unlike some TROs, a preliminary injunction always needs notice and hearing, correct? Both sides get to argue.
Always. Notice and an opportunity to be heard are required for a preliminary injunction.
Okay, let's shift gears to the documents that actually start and define the lawsuit. The pleadings. The complaint is obviously step one.
It is. That's the document that gets the ball rolling. Angela's notes boil it down to 3 essential components you absolutely need in there.
Right. First, jurisdiction. You got to tell the court why it has the power to hear this case. Is it a federal question based on federal law or diversity? Diversity meaning parties from different states and enough money at stake, right? We don't need to get lost in the weeds on those now, but they're the entry ticket to federal court. What's a common mistake there?
A really common one is just stating residency instead of citizenship for diversity, or not clearly alleging the facts that support federal question jurisdiction. You need specifics.
Okay, specifics on jurisdiction.
Yeah.
What's number 2?
Number 2 is that short and plain statement of the claim showing you're entitled to relief. This is, the core of notice pleading. You need enough facts to make the claim plausible, not just conceivable.
Plausible, right. That's the standard from cases like Twombly and Iqbal. You can't just make bald assertions. You need factual support.
Exactly. Pleading legal conclusions without the underlying facts. That's a classic way to get your complaint dismissed.
And the third piece is the demand for judgment, what you actually want the court to order. Angela's notes say this doesn't cap your recovery, though, except in default cases.
That's right. If the case goes to trial, you can recover more than you initially demanded. The demand really just gives notice. Only if the defendant defaults are you limited to what you asked for in the complaint.
Interesting. And courts are a bit easier on pro se folks, people representing themselves, but the core requirements still apply.
They do. Okay, so after the complaint comes the answer, the defendant's response. They can admit things, deny things, or say they don't know. What happens if they admit something?
Well, that's basically locked in, isn't it? If you admit an allegation, you generally can't argue against it later unless you get the court's okay to amend your answer.
Precisely. It takes that issue off the table. Now, denials. You can do a general denial, deny everything, or specific denials for each point. Angela's notes warn about general denials, though.
Yeah, seems risky. If you deny stuff you know is true, that looks bad at the court, right? Undermines your credibility from the start.
Definitely. Now, what if circumstances change or you realize you need to fix something in your complaint or answer? That brings us to amended and supplemental pleadings.
Right. You get one free shot, sort of. Angela's notes say you can amend once as of right, no permission needed, within 21 days of serving it, or within 21 days after the other side serves their response, or a motion like a Rule 12b motion.
Correct. That initial window is pretty clear, but what if you miss it?
You need permission, right? Leave of court.
Yes. You file a motion asking for leave to amend. And the rule says courts should freely give leave when justice so requires. Usually they will, unless there's a good reason not to.
Like what? What's a good reason to deny leave?
Things like undue delay, bad faith, dilatory motive, repeated failure to fix deficiencies, or if the amendment would be futile, meaning it wouldn't survive a motion to dismiss anyway, or, importantly, unfair prejudice to the other side.
Prejudice like having to redo a bunch of discovery late in the game.
Exactly. If the amendment radically changes the case right before trial, that's likely prejudicial. Now, if you do amend, the other side generally gets 14 days to respond to the new pleading or the rest of their original deadline, whichever is longer.
Okay. Angela's notes also mention relation back. This sounds important for deadlines like the statute of limitations.
Oh, it's critical. Relation back lets an amendment, sometimes even one adding a new party, be treated as if it were filed with the original pleading. For adding a new party after the statute of limitations has run, it's tricky. The claim against the new party has to arise from the same conduct or occurrence set out in the original pleading. And, crucially, the new party must have received notice of the lawsuit within the time allowed for serving the original complaint, so they aren't prejudiced in defending themselves. Plus, they had to know, or should have known, that the lawsuit would have been brought against them if not for a mistake about their identity.
Wow. Okay. So it's not automatic, but it can save a claim. And supplemental pleadings. That's for stuff that happened after the first filing.
Correct. If events relevant to the case happen after you filed your complaint or answer, you use a supplemental pleading to bring them in. You always need court permission for that.
Got it. So pleadings set the stage. And then there's Rule 11, making sure people play fair with those documents.
That's the one. Rule 11 is all about accountability. Angela's notes stress that pretty much every paper filed with the court, pleadings, motions, etc., though not most discovery documents, needs to be signed by an attorney or the party if they're pro se. And that signature isn't just a name, it's a certification.
Certification of what, exactly? What are you promising the court when you sign?
You're certifying, after making a reasonable inquiry under the circumstances, several things. One, it's not being presented for any improper purpose, like harassment or delay. Two, the legal claims or defenses are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law.
Okay, so no baseless legal arguments.
Right. Three, the factual contentions have evidentiary support or, if specifically identified, will likely have support after discovery.
And four?
Four, the denials of factual contentions are warranted on the evidence or, if noted, are reasonably based on a lack of information or belief. It covers all the bases.
So reasonable inquiry is key. You can't just file first and figure out the facts later.
Not anymore. That's the whole point. And if you violate Rule 11, sanctions can be imposed on the attorney, the law firm, the party, or maybe all of them.
What kind of sanctions?
Could be non-monetary directives, like striking the paper or monetary penalties. But Angela's notes highlight an important point. Monetary sanctions for claims not warranted by law usually can't hit the client, only the attorney or firm.
Because the client relies on the lawyer's legal judgment. That makes sense.
Exactly. The client might not know the legal argument is frivolous. Angela's example was good. Filing a general denial without checking basic facts or denying venue improperly. Clear Rule 11 issues.
And there's that safe harbor thing, right?
Yeah.
A 21-day window.
Yes, very important. Before filing a Rule 11 motion with the court, you have to serve it on the opposing party first. They then have 21 days to withdraw or correct the challenged paper.
So it encourages fixing mistakes before involving the court.
Precisely. It aims to deter, not just punish, and avoids unnecessary satellite litigation over sanctions.
Okay, pleadings, Rule 11. Now, how about getting all the right players and claims into the same lawsuit? That's Joinder, right?
Yep. Joinder rules govern who can be made a party and what claims can be brought. Rule 18 is simple. A party asserting a claim can join as independent or alternative claims, basically any other claims it has against the opposing party. Very broad.
So if I'm suing someone for breach of contract, I can add an unrelated tort claim I have against them in the same suit.
You can. It promotes efficiency. Now, joining parties is a bit more structured. That's Rule 20, permissive joinder.
When can multiple plaintiffs join together, or when can a plaintiff sue multiple defendants?
Plaintiffs can join if they assert rights to relief jointly, severally, or alternatively arising out of the same transaction or occurrence, and if any quotient of law or fact common to all plaintiffs will arise. Same test applies for joining multiple defendants. Same transaction occurrence, common question of law or fact. What's a reason plaintiffs might want to join up?
Strength in numbers. Sharing costs. Maybe presenting a more unified front to the court or jury.
Could be. Now that's permissive joinder. Sometimes joinder is compulsory under Rule 19. These are parties the court calls required or historically necessary.
Who's considered necessary?
A party is necessary if, without them, the court can't grant complete relief among the existing parties, or if that person claims an interest relating to the lawsuit and proceeding without them might impair their ability to protect that interest, or leave an existing party subject to, like, double or inconsistent obligations.
Okay, so their absence messes things up significantly. What if they should be joined, but adding them would ruin the court's jurisdiction? Like adding someone who destroys diversity. Angela's notes mention this.
That's the tough spot. If a necessary party cannot be joined because of jurisdiction or venue problems, the court has to decide whether, in equity and good conscience, the action should proceed without them or be dismissed.
Dismissed.
Yes. The rule lists factors to consider, like whether the plaintiff has an adequate remedy if the action is dismissed. Maybe they can sue in state court where everyone can be joined. If the party is deemed indispensable, the case gets dismissed.
Wow. Okay, so joinder isn't always straightforward.
Yeah.
What about claims between existing parties on the same side? Like defendant versus defendant.
Those are cross-claims under Rule 13G. A party can file a claim against a co-party, but it must arise out of the same transaction or occurrence as the original action or a counterclaim. They're never compulsory.
Okay. And defendant versus plaintiff. Those are counterclaims.
Right. Rule 13A covers compulsory counterclaims. These arise from the same transaction or occurrence as the plaintiff's claim. You must assert them in the current lawsuit, or you generally waive the right to sue on them later.
Use it or lose it.
Pretty much. Then there are permissive counterclaims under Rule 13B. These are any claims the defendant has against the plaintiff that don't arise from the same transaction. You can bring them, but you don't have to. And importantly, they need their own independent basis for federal jurisdiction.
Got it. Now, what if a defendant thinks, hey, if I'm liable to the plaintiff, then this other person should have to pay me back? Angela's notes call this impleader.
Exactly. That's third-party practice under Rule 14. A defending party, as a third-party plaintiff, can serve a summons and complaint on a non-party who is or may be liable to them for all or part of the claim against them. Think indemnity or contribution.
So bringing someone new into the mix because they might owe the defendant, does that need its own jurisdiction?
Often, impleader claims fall under supplemental jurisdiction, meaning they can piggyback on the main claim's jurisdiction, even if there wouldn't be independent federal jurisdiction over the third-party claim itself.
Okay, and what if someone outside the lawsuit wants in? That's intervention, Rule 24.
Correct. An outsider might want to intervene to protect their interests. There are two types. Intervention of the court must allow it if the intervener claims an interest relating to the property or transaction. Resolving the case might impair their interest, and the existing parties don't adequately represent that interest.
And the other type?
Permissive intervention. The court may allow it, in its discretion, if the intervener has a claim or defense that shares a common question of law or fact with the main action. But the court considers if it will unduly delay or prejudice the existing parties.
Lots of ways to get parties in and out.
Yeah.
Finally, under joinder, Angela's notes cover the big one. Class actions, Rule 23.
Ah, yes. Where one or more people sue or are sued as representatives for a larger group, the class, you need those four prerequisites. Numerosity, class is too large for regular joinder. Commonality, common questions of law or fact. Typicality, reps' claims defenses are typical of the class. And adequacy of representation, reps will fairly protect the class.
Numerosity, commonality, typicality, adequacy. Got it. And then?
Then the proposed class action also has to fit into one of the categories under Rule 23B. For example, where separate actions would create inconsistent rulings, or where injunctive relief for the whole class is appropriate, or the most common type where common questions predominate and a class action is superior to other methods.
And jurisdiction in class actions. Angela mentioned something specific.
Traditionally, for diversity, you only looked at the citizenship of the named representatives. But the Class Action Fairness Act, CAFA, made it easier to get big multi-state class actions into federal court under diversity rules, using minimal diversity and an aggregate amount in controversy over $5 million.
Okay, CAFA changes things for big cases, and Angela's notes had that interesting point about state law.
Right. Even if the class action is based on state law rights, federal procedural rules, like Rule 23 itself, govern how the class action proceeds in federal court. A state law trying to prohibit class actions for certain state claims generally won't stop a federal court from certifying a class if Rule 23 is met.
Federal procedure wins in federal court.
Yeah.
And settlements always need court approval.
Absolutely critical in class actions. The court acts as a guardian to ensure any settlement is fair, reasonable, and adequate for all the absent class members.
Okay, deep breath. That's parties and claims. Now, on to discovery, the evidence gathering phase. What's the general scope here? Angela's notes say it's broad but not unlimited.
Exactly. Rule 26b1 defines the scope. Parties can obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case.
Relevant and proportional. What goes into proportionality?
The court considers factors like the importance of the issues, the amount in controversy, the party's relative access to the information, the resources, the importance of the discovery in resolving the issues, and whether the burden or expense outweighs its likely benefit.
So it's a balancing act. And the info doesn't have to be admissible evidence itself.
Correct. Information within this scope is discoverable even if it wouldn't be admissible at trial, as long as it appears reasonably calculated to lead to the discovery of admissible evidence.
Okay. Now, Angela's notes talk about initial disclosures under Rule 26A, things you have to hand over without being asked.
Yes. Early in the case, usually after the parties have their initial planning conference, the Rule 26 conference, they have to automatically disclose certain core information. Things like names and contact info of individuals likely to have discoverable information supporting your claims or defenses, copies or descriptions of documents, ESI, and tangible things you might use to support your case, a computation of damages, and any insurance agreements that might cover a potential judgment.
So putting some cards on the table right away. And formal discovery waits until after that initial conference.
Generally, yes. Unless the parties agree otherwise or the court orders it, you can't start using interrogatories or depositions until after the Rule 26 conference.
Okay, then what are the main tools for formal discovery?
You've got interrogatories, Rule 33, written questions served on another party who must answer them in writing under oath. Limited number, usually. Requests for production, Rule 34, asking another party to produce documents, ESI, or tangible things for inspection, or to permit entry onto land. Depositions, Rule 30 for oral, 31 for written, taking sworn testimony from a party or even a non-party witness before trial, crucial for locking down testimony. And requests for admission, Rule 36, asking another party to admit the truth of certain facts, the application of law to fact, or the genuineness of documents, helps narrow the issues for trial.
How do you get info from non-parties? They aren't bound by discovery requests, are they?
Not directly. For non-parties, you generally need a subpoena, Rule 45, to compel them to testify at a deposition or produce documents.
Okay, subpoena for outsiders. Angela's notes flag ESI, electronically stored information. That seems huge now. Any special rules?
Definitely. Rule 34 allows requesting ESI. The requesting party can specify the format they want it in. The responding party can object. If no format is specified, or if the responding party objects to the requested format, they have to produce it in the form it's ordinarily maintained or in a reasonably usable format. You generally don't have to produce the same ESI in more than one format.
Makes sense. Avoid duplication. What about things prepared for the lawsuit? Like lawyer's notes. Angela mentioned work product.
The work product doctrine, Rule 26b3. This protects materials prepared in anticipation of litigation or for trial by or for another party or its representative, like lawyers, consultants, insurers. It's generally not discoverable unless the party seeking it shows they have a substantial need for the materials to prepare their case and cannot, without undue hardship, obtain the substantial equivalent by other means.
So it's protected, but not absolutely.
Correct. Factual work product can sometimes be obtained, but the rule gives near absolute protection to what's called opinion work product, the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative. That's almost always shielded.
Okay, protect the strategy. What about experts we plan to use at trial?
Rule 26A2 requires disclosure of testifying experts. For experts retained or specially employed to testify, you usually need to provide a written report containing their opinions, the basis for them, the facts or data considered, their qualifications, publications, compensation, and a list of other cases they've testified in.
That's pretty detailed. Then closer to trial, there are more disclosures. Pretrial disclosures.
Yes, under Rule 26.8. Usually at least 30 days before trial, parties have to disclose the witnesses they expect to call, those they might call if needed, deposition testimony they plan to present, and exhibits they expect to offer or might offer.
Laying the final cards on the table. What if someone objects to using one of those witnesses or exhibits?
Objections to the admissibility of the disclosed materials, except for relevance, prejudice, or confusion under Evidence Rules 402 and 403, are waived unless made within 14 days after the disclosure.
Okay, use it or lose it on objections too. Now, what if parties just don't cooperate? Don't make disclosures, ignore requests. Angela's notes mention sanctions under Rule 37.
Oh, yeah. Rule 37 provides the teeth for discovery enforcement. If a party fails to disclose or cooperate, the other side can file a motion to compel. If they still don't comply, or if the failure was egregious, the court has a range of sanctions. It can order facts be taken as established, prohibit the disobedient party from supporting or opposing certain claims or defenses, strike pleadings, stay proceedings, dismiss the action, or even enter a default judgment.
Serious consequences.
Very. And if a party fails to admit something under Rule 36 that's later proven true, they might have to pay the reasonable expenses, including attorney's fees, incurred by the other party in proving it.
Ouch. Pays to be truthful in admissions. What if discovery just gets overwhelming or abusive? Can you ask the court for help?
Absolutely. That's what protective orders under Rule 26C are for. A party can move for an order to protect them from annoyance, embarrassment, oppression, or undue burden or expense. The court can then issue orders like forbidding the discovery, limiting its scope, specifying terms like time or place, sealing depositions, or protecting trade secrets or confidential information.
Okay, so there are checks and balances. Now, sometimes cases end without a full trial. What are the main ways that happens? Angela's notes start with the full judgment. Rule 55.
Right. If a defendant completely fails to plead or otherwise defend against the lawsuit, the clerk can enter their default. Then the plaintiff can seek a default judgment. Liability is usually taken as established by the default, but damages often still need to be proven, typically in a hearing. And if the defaulting defendant has appeared in the case at all, they generally have to be given notice of the damages hearing.
Okay, so failing to show up is risky. What about the plaintiff just deciding to drop a case?
That's voluntary dismissal under Rule 41. A plaintiff can usually dismiss their own case without a court order simply by filing a notice of dismissal before the defendant serves an answer or a motion for summary judgment.
But only once, without prejudice, right?
Typically, the first voluntary dismissal is without prejudice, meaning they can refile the lawsuit later. But if they dismiss the same claim again, the second dismissal is usually with prejudice, barring them from suing on that claim ever again.
Okay. Now, what if the defendant does respond, but thinks the case is fundamentally flawed from the start?
Yeah.
Motion to dismiss, Rule 12b.
Exactly. A defendant can file a motion to dismiss based on several defenses listed in Rule 12b. Things like lack of subject matter jurisdiction, 12b1, lack of personal jurisdiction, 12b2, improper venue, 12b3, insufficient process or service, 12b4 and 5, failure to state a claim upon which relief can be granted, 12b6, or failure to join a required party under Rule 1912b7.
That 12b6, failure to state a claim, sounds like the plausibility standard we talked about earlier.
It is. That's where the court asks if the facts alleged in the complaint, taken as true, state a claim that is plausible on its face.
And Angela's notes mention some of these defenses are waivable.
Yes. Defenses like lack of personal jurisdiction, improper venue, and problems with process or service must be raised in your first Rule 12 motion or in your answer, whichever comes first. If you don't raise them then, you've waived them. Subject matter jurisdiction, though, can be raised anytime, even on appeal.
Good to know. What about judgment on the pleadings? Rule 12c. How's that different from a 12b section?
It's similar in that it challenges the legal sufficiency of the case, but it happens after the pleadings are closed, meaning after the complaint and answer and any reply to a counterclaim. The court looks only at the pleadings themselves and decides if the moving party is entitled to judgment as a matter of law based just on those documents. No outside evidence.
Okay. But the really big one for ending cases before trial seems to be summary judgment. Rule 56.
Definitely. This is a major hurdle in many cases. Summary judgment can be sought by either party. The standard is there a genuine dispute as to any material fact? And is the moving party entitled to judgment as a matter of law?
No genuine dispute of material fact. What does that mean in practice?
It means that looking at the evidence submitted, like affidavits, deposition transcripts, interrogatory answers, is there a real disagreement about a fact that could actually affect the outcome of the case? If the only disputes are about minor details or if the facts aren't really contested, summary judgment might be appropriate.
And the court views the evidence how?
Crucially, the court must view all evidence in the light most favorable to the non-moving party and draw all reasonable inferences in their favor.
Angela's notes emphasize that the non-moving party can't just rest on their pleadings, right? They have to show real evidence.
Absolutely. Once the moving party makes a proper showing, the burden shifts to the non-moving party to come forward with specific evidence affidavits, discovery responses showing there is a genuine factual dispute for trial. You can't just say, "My complaint says otherwise."
And credibility. Angela's notes said summary judgment isn't for weighing witness credibility.
Correct. If resolving a key factual issue depends on whose witness the jury believes, that's a classic issue for trial, not summary judgment. Summary judgment is only proper if no reasonable jury could find for the non-moving party based on the evidence presented.
Okay. And if summary judgment is denied, you just proceed toward trial. It's not usually appealable right away.
Generally, no. A denial of summary judgment just means the case needs to go to trial. It's usually not a final appealable order.
All right. Last major phase Angela covers.
Right.
The pretrial conference and order under Rule 16, getting ready for trial.
Right. Rule 16 aims to manage the case efficiently. Early on, the court usually must issue a scheduling order after consulting with the parties, often at a scheduling conference.
What does that order do?
It sets deadlines for things like joining parties, amending pleadings, completing discovery, and filing motions. It's the roadmap for the pretrial phase, and Angela notes it can only be modified for good cause and with the judge's consent. Keeps the case moving.
So keeps everyone on track. Are there other conferences?
Yes, the court can hold additional pretrial conferences to facilitate settlement, simplify issues, obtain admissions, rule on evidence objections, and generally streamline the trial.
And then there's the final pretrial conference.
Usually held close to the trial date. The goal here is to formulate a plan for the trial itself, including managing witness testimony and exhibits.
And the result is a pretrial order. How important is that?
Extremely important. The final pretrial order outlines the issues to be tried, witnesses, exhibits, stipulations, etc. Angela's notes stress that this order controls the course of the trial unless the court modifies it, and modification only happens to prevent manifest injustice. It basically supersedes the pleadings.
Wow. So that final order really locks things down for trial. We have covered a ton of ground today, really digging into those pretrial steps, all thanks to Angela's great notes. It's quite something how much happens before you ever see a courtroom for trial.
It really is. These rules and procedures are the scaffolding for the entire litigation process. Understanding them is just crucial, whether you're prepping for the bar or just trying to understand how civil lawsuits actually work.
It definitely highlights how strategic lawyers need to be right from the very beginning. It's not just about the trial itself. What part of this whole pre-trial landscape do you find has the most, maybe, surprising impact on how a case turns out?
That's a good question. Maybe the power of discovery sanctions, or how effectively summary judgment can sometimes resolve complex cases without the expense of a full trial. It forces parties to really evaluate the strength of their evidence. Think about exploring maybe the nuances of e-discovery disputes or the strategic timing of dispositive motions.
Food for thought. Well, thank you again to Angela for giving us such a solid framework for this deep dive. Keep studying, keep questioning these rules, and we'll catch you next time for another look into the world of law.
Hey, this is Angela again. I'm coming back at you. So that was interesting, pretrial procedures. And I feel like even though I've worked as a judicial law clerk and even though I have done bar study, every time I study something like this, I pick up on something that I hadn't really realized before. Anyhow, thank you for listening. If you'd like to get in touch, you can email me at podcast@studyforthebarinyourcar.com. And if you need to reach me for any sort of legal help, so if you're an attorney and you need some assistance, too much work on your hands and you need a ghostwriter, you can reach me at hello@legalwriterandlawclerk.com. Thank you for listening. Keep in mind that AI isn't always 100% correct, but I try to keep things as correct as can be. Thank you so much, and we'll see you on the next episode.